My name is Susanna Gergich. I'm the Manager of Learning Development here at Pillar Nonprofit Network. Some few quick housekeeping items, and then we'll hand things off. Welcome and thanks for joining us. If you don't know a little bit about Pillar Nonprofit Network, we strengthen individuals, organizations, and enterprises invested in positive community impact. We support nonprofits, social enterprises, and social innovators. We are located in London, Ontario. We have a really fun, creative co-working space here in London, Ontario, and provide all kinds of different supports and resources for the social impact sector. One of them being workshops and webinars and information sessions like this. So that's who we are. If you want to know more about us, feel free to reach out. I have a couple of colleagues on the call with me. And if you notice, I'm kind of going back and forth. I'm just looking at my notes, trying to keep an eye on the screen, and also keep an eye on my email in case someone has challenges getting in. So I have Paul Seal is on the call, and Mariam, wave. And Zenbing as well is she's doing an internship and supporting Pillar. So I wanted to thank our 2022 Learning Development sponsors, Western Continuing Studies, and as well Fanshawe Employment and Student Entrepreneurial Services, along with Fanshawe Corporate Training Solutions. So we're excited to get to work with them. I am going to share with you in the chat. These are our virtual community agreements, and we use these for all of our events. You might see me copy and paste them again. If someone joins us late, I might recopy and paste a few things. So these are our virtual community agreements. If you could, because we're recording, maybe I'm going to read them out just so that we have it. Address the issue, not the person. Lean into discomfort. Be respectful of others on their terms. Expect and accept non-closure. Acknowledge that we are all on a journey, and part of the journey is growth. Show up with humility and empathy, even if opinions differ. Be patient and accountable to one another to ultimately build trust with one another. Confidentiality. What's said here stays here. What's learned here leaves here. And just please note that Pillar Nonprofit holds the right to remove any attendees that do not support these agreements in co-creating a safe, brave, and accountable space. So just wanted to take a moment to share those. I will say it's really strange because I know we're recording and we just never record anything. So if I seem flustered, that's probably why I'm not used to it. A few quick things about Zoom. I'm not going to go over it other than to note that you are muted. You're welcome to unmute yourself when we have a chance for conversations and discussion. What else can I tell you? If you do have any technical difficulties, feel free to reach out to me. You can send me a direct message. You can email me. I'll do my best to help you. If you, there will be opportunity for questions, and I believe that because we have a nice small group that will be able to do that. Just more, we'll be able to talk. You can unmute yourself and ask a question, but feel free to throw that question in the chat. Benjamin's giving me a thumbs up, so I said that correct, which was good. If you have a question that you'd like to ask anonymously, that's okay. Send it directly to me and I will ask it on your behalf. I'm happy to do that. What else can I tell you about Zoom? Maybe that's about it. Some different ways to view it. If the top right-hand corner, speaker view or calorie view, feel free to do that. And feel free to use the chat. Chat is a great function for us to engage with. I'll probably drop in some links and some things. So you're going to see me doing that. And then just a reminder again about that closed captioning. So you can enable it or disable it along the bottom there. There's that feature. And finally, at the end of the session, I will drop a link. I'll drop a link to a few things, some events that are coming up, and as well as an evaluation that I would love for you to complete. And I would suggest click on that link, that evaluation link. It'll pop up in your browser, and then you can fill it out right after the fact. I'll also follow up in an email with that link and some other resources as well. So I think that's all I have for myself. Feel free to reach out to me. I'm going to be hanging out here listening and learning myself and happy to help. I'm going to hand things over to Benjamin. And so Benjamin, I will say, he delivered a couple of months ago a session for us around the Ontario Nonprofit Corporations Act, which recently there were changes and updates. And along when we were having that conversation, Paul Seal, that's on here, colleague, we had a conversation around we get a lot of questions in our office from groups that are not incorporated. They are not a registered charity for various reasons, whether or not they want to stay more grassroots or they're maybe looking at that in the future. And we were just trying to sort out what are the options that exist for them. And that's where the idea of this session came up, and Benjamin was very open to delivering it. So that's kind of how we got here. He's a staff lawyer on the Nonprofit Law Ontario project of the Community Legal Education Ontario, CLEO, where he focused on nonprofit and charity law and policy. Over the last 4 years at CLEO, Benjamin has answered hundreds of nonprofit law questions and developed an online interactive bylaw builder for the ONCA. I would suggest if you are looking at incorporating, and I'm sure Benjamin will go over this, or are incorporated, there's some great resources on their website. Benjamin also works at the Ontario Nonprofit Network and has worked at the Canada Raven Agency in the past. He holds a JD and NPP from the University of Toronto and an MA in political theory from the University of Ottawa. And I know there's going to be lots of great information. So thank you, Benjamin, for being here. I'm going to hand things over to you.
Thank you so much. Thank you for having me. I love this topic in particular, the law that applies to unincorporated associations. Because one, there's very little out there about it. It's a time of great flexibility for groups, and therefore fascinating and imaginative questions. And it's an underappreciated area. So I really relish the opportunity to speak with unincorporated groups or individuals interested in this area. I learn an enormous amount from the questions. So it's very much a relationship of reciprocity. So thank you all for being here today, and in advance for your questions. So I'm going to speak about three general things today. Firstly, I'm going to speak about the rules that apply to unincorporated associations while they're unincorporated. Secondly, I'll look at the different structures that are available to unincorporated associations if they're looking to become more formal. Differences between nonprofits and charities, between for-profits and nonprofits, between co-ops and not co-ops, understanding the difference between all these things. And understanding different ways to structure one's membership, and we'll talk about what that means. And then finally, in the last section, I'll be much more kind of step-by-step, straightforward sort of information about if you do want to incorporate as a nonprofit, well, how do you go about actually doing that? After each of these three sections, I'll pause. And we can have a discussion, which, as Susanna has already said, you can unmute yourself, you can type the questions in the chat at any time. It's a small enough group that I hope we can have a nice discussion. And Pillar's allotted a good amount of time, which is always, I always appreciate that. So I'm from Community Legal Education Ontario. You've already heard this. You may not know about us. We're a legal clinic, part of Ontario's legal aid system. In contrast to other legal clinics that provide one-on-one legal services and advice, what we do is we provide general legal information and education opportunities like this one. We have a number of websites where there's a lot of free legal information and resources on topics that may be of interest to you or to your clients or members. For example, employment law, family law, criminal law, immigration law, etc. So what I do at CLEO is just, thank you very much, Santa, for sharing that. What I do at CLEO is just a small corner of what we do. I would encourage everyone here, if you're curious, to check out some of our other websites like stepstojustice.ca. Questions are very important. Now, I'm a lawyer, and you know how lawyers are. We love our disclaimers. I have not one, but 4 disclaimers. And for the people who attended the ONCA session, you know I'm fond of having at least 4 disclaimers. The first is, this is general legal information. It isn't legal advice. And it's not because I don't want to give you advice. It's because I can't really effectively give you advice because I don't know your situation well enough. And there are a lot of variables and a lot of specific things that could change what the advice is. So unfortunately, today I cannot give you advice, only general information. Number 2, this is a high-level overview of corporate law, what would be called corporate law. It isn't comprehensive and it doesn't address all areas of law that may be relevant to you. For example, you may be interested in becoming a registered charity. If you have questions about that, I'm happy to address them. But generally speaking, I won't be talking about charity law. You may be interested in joining a regulated sector like childcare or healthcare, etc. That's not an area I know in particular, so I won't be addressing that. I'll just be addressing your corporate law aspects. Thirdly, this is about law and it's not about best practices. So just because something is legal doesn't mean it's a good idea. My goal today is to highlight options for you. And I think it's perhaps a widely held myth that lawyers know anything other than law. Just because I know about the law of unincorporated associations doesn't mean I'm qualified or an expert to help you in how to reach your community and how to build your community. You probably know a great deal more than I do about how to do that effectively. I'm going to try my best to stay in my lane and not pretend just because I know the law that I know what's best for your community. And finally, this is about law and it's not about your funders' expectations. So laws of various kinds establish minimums that if you don't meet those minimums, there may be consequences. However, your funders, your community members, your donors, etc., they may all have their own expectations quite above and beyond or besides what the law requires. And those are very important conversations to have with them. It's not something within the scope of today's presentation. So with that in mind, before we jump in to the content, I want to, of course, acknowledge the land that I'm coming to you from. I'm situated here in downtown Toronto, the traditional territories of the Mississaugas of the Credit, the Haudenosaunee, and the Wendat, and is now home to many diverse First Nations, Inuit, and Métis relatives. And Cleo's work is carried out across the many traditional territories of this land. So I would encourage you to reflect on where you are on the land and check out, for example, nativeland.ca to learn more about whose traditional territory that is. I want to specifically acknowledge my privilege as well as my role in systems of colonization as a lawyer. Indigenous peoples on this land have been systematically denied access to the law and to lawyers. The Indian Act criminalized speaking to a lawyer about land rights. So I'm aware, I'm conscious of the fact that I'm part of that tradition, the tradition of that profession. I'm also conscious of the fact that as a lawyer who deals with corporate law, that corporations, nonprofit as well as for-profit, have been used as legal devices to evade responsibility for harms done as part of colonization for hundreds of years, and they continue to be used in this way. So my hope is that you use the information from this session to build more accountable rather than less accountable communities. Additionally, as we think specifically about the law that applies to unincorporated association and where do unincorporated associations fit within the process of reconciliation, I would invite you to consider the following. Even if you were to follow all the laws that are written down in the province of Ontario, from the government of Ontario, the Ontario Not-for-Profit Corporations Act, if you were to register as a charity under the Income Tax Act, none of that would guarantee that you've even taken the first steps towards reconciliation. But unincorporated associations are at a special stage. There's a lot of flexibility for them. There's a lot of creativity that's available to you that I'm going to highlight today and how you build your governance. And you may still be quite young in your development as an organization, not necessarily, but you might be. And so it's an ideal time for you to ask yourselves the question, who's at the table? How are we holding ourselves accountable and building lines of accountability to the Indigenous peoples, nations in our area? So that's not something that I'm going to be able to address when talking about the law of unincorporated associations, but it is something that you can address as part of the ongoing process of reconciliation. Okay, so that brings us to the first section, rules for unincorporated associations. I'm going to talk about 4 things. Number 1, how to start an unincorporated association, which you may say to yourself, well, I've already started one. Why do I need that? Well, Patience, you'll find out in a second. Number two, constitutions. You may call them bylaws, governing rules, that document where you set out your rules of governance. We're going to talk about what you might want to include in that, what's the effect of having these things written down, what happens if you don't have certain rules written down. Number three, who makes decisions in an unincorporated association? I get this question often. This person is doing such and such. Do they have the right to do that? It's really important for the health of the relationships in an unincorporated association that it's clear who has the right and power to do what. So I'll talk a bit about what the law sets as the default. Number four, how is property handled? Often when there are disputes within unincorporated associations, and in the rare cases where it actually goes to court, it's because there's property and people have different ideas about who's actually entitled to that property. So this is a really important thing to get clear on from the beginning. Okay, so how to start an unincorporated association. An unincorporated association is a group of people, so that means two or more people, who have decided to do things together for a purpose or goal other than profit. If the goal is profit, even if one of the goals is profit, so you may have multiple goals, but if any one of those goals is profit, two or more people coming together with a view to profit are governed by partnership law, not the law of unincorporated associations. So the first thing to note is that unincorporated associations are any group of two or more people coming together to do something other than profit. It could be anything, but it's not profit. And it happens automatically. You don't need to register with any government department. You don't need to make any filings, which means that you could be an unincorporated association without realizing it. And the rules governing you could be the rules of unincorporated associations. And there are no federal or provincial laws that govern unincorporated associations. And by laws, I mean legislation. So it's not something that you can Google and say, the Unincorporated Association Act of Canada or the Unincorporated Associations Act of Ontario. There's no such thing. There have been some attempts in the past to get these things more formal and standard and written down. But as of now, there's no such thing. So that raises the question, where do the laws for unincorporated associations come from? Well, they come from court cases that have accumulated over hundreds of years of people getting together to do things for purposes other than profit. And unless you're a lawyer who's paid a great deal of money to access databases of all these cases, chances are you do not have access to the cases where these laws are set out. And you wouldn't necessarily, know how these cases fit in the historical trajectory of all these cases, right? That's sort of what they train you in law school for. So unfortunately, the rules are really inaccessible. So the good news is on our website, which I will share at the end of the presentation, but I'll also put it in the chat now, nonprofitlaw.clio.on.ca, because we were getting so many questions from unincorporated associations, we created a quick page that sets out some of the most important rules. So that's one place you can go for information on unincorporated associations. But the key thing I want to flag here is that just because something isn't written down in an act doesn't mean there isn't a rule about it, that you should assume you can just do whatever you want. That isn't necessarily the case. So constitutions or bylaws or governing rules or what you may call it, anything you want. A rose by any other name would smell as sweet. Bylaws by any other name would have the same legal effect. Constitution by any other name would have the same legal effect. It's that document that has your terms, what you've agreed on of how to work together within the unincorporated association, your rules of governance. Now, constitutions can sound imposing. You could have Article 1, or you could have Roman numerals I, double I, IV, all these things. They can be very formalistic and intimidating in how they're written out, but they don't have to be. Fundamentally, what a constitution is a frequently asked questions for the governance rules of your organization. And you're welcome to format them that way if it makes it more accessible to the people in your group to consult them and understand what the rules are. So if there are frequently asked questions, what are those questions that our lawyers recommend and cases often turn on? What are those questions that constitutions most often deal with? So number one, what are the purposes or goals of your group? It's really important to specify, written down somewhere, what the purposes or goals of the group are, because everything the group does is going to be, from a legal point of view, in the service of those purposes. So that if you want to complain that somebody has misused your property, for example, and you want to say, well, that's not what our group is about. You used it for X, but our group is about Y. Well, prove it. How do we know your group is about Y, right? Having a written down set of purposes is a great starting point, firstly, to get clarity within your group. It can be a good group building exercise. But secondly, if there's ever a concern that somebody is using your property or your name for something other than your purposes, that you can actually point out, no, 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 this is outside the scope of what we're doing. You don't have that authority. Number two, who is a member? Members are the lifeblood of the unincorporated association. They are the people who by default control it. As I'll explain in a bit, by default, the law assumes that decisions are made by consensus. But consensus of who? Consensus of the members. So understanding who is and who isn't a member is vital to understand who has rights in your organization. So specifying who is a member, specifying how somebody becomes a member, specifying what rights they have as a result of being a member, and specifying how membership ends is really important. Why is it so important to specify how membership ends? Because if there isn't a clear method for how membership ends, and somebody is being, problematic, right? Maybe they misuse property, or maybe they're they're harassing other members, or it's just becoming toxic, or something like that. Having a clear and fair process for how somebody can be removed or disciplined is really vital to ensuring that you can quickly resolve any problems within the group. And what courts look for is, was there a fair procedure? And if there was a procedure set out in writing somewhere, was it actually followed? Which raises a very important point. If you do write anything out, make sure you actually live up to that. How are decisions made? And we'll talk a bit more about this on a coming slide. Constitutions can provide, clarity on whether or not there's an executive. The law doesn't assume that somebody's the president and somebody's the secretary. There doesn't have to be. You could be collective in your decision making. All the members vote collectively. You could say there's a president. You could say there's a principal. You could call it whatever you want. You could have whatever structure you want, which is why an unincorporated association is such an interesting time because there's all this flexibility in the law. But the flip side of the flexibility is that there isn't clear structure unless you set it out somewhere. So is there an executive or not? Do you decide by consensus or majority? The law doesn't assume that decisions are made by majority, even though that may be what you assume. A really important area, as I mentioned, how will you deal with property? Who does the property belong to? Who will it go to if your unincorporated association closes down, it stops working? Who's going to be left holding the bag? Who are they responsible to give that money and property to? And finally, how do you change your constitution? So constitutions are not a once and done thing. Even the best constitution in the world will have to change from time to time as groups evolve, new people come in, other people leave, and ideas and purposes of the organization shift. And so having a clear process for changing the constitution can make it easier to adapt as the organization grows. If you don't write these things down, what's going to happen? Well, if it's not written down, a court will look to your common practices. So what if you've existed for many decades, which is sometimes the case, and an unincorporated association has been around for a long time, and you've just always done things this way. No one ever wrote it down. It's always done that way. Well, a court will look at that and say, okay, we're going to interpret that as your practice, as your unwritten rules. If you have no clear practice, meaning you haven't been around that long, or it seems to change from year to year, there isn't any clear pattern, then on the next slides, we're going to talk about certain defaults that the law assumes. So let's talk about who makes decisions and what the default the law assumes is. Members of an unincorporated association can structure the association in any way that they like, right? This is one of the big messages to bring home. An association doesn't need to feel constrained by typical structures, such as a chair, president, secretary, treasurer. They can get creative. And this is one of the great opportunities I was mentioning earlier in thinking about accountability to Indigenous communities, accountability to the communities you serve, in having a governance structure which reflects one's ideals rather than just defaulting to, well, this is how it's done in the nonprofit sector. That must be the best way to do it. Every organization needs to figure out for itself what's to make sense in its situation. If you don't write down how you make decisions, then the court will assume decision-making is based on consensus and not by majority vote. This is sometimes referred to in court cases as the clubman's veto. So that's important to keep in mind, because if you haven't defined things and everybody agrees except for one person, right, then that person can all of a sudden wield a lot of power in the organization that could be unanticipated. How is property handled? Well, the default is that property belongs to everyone unless written rules say otherwise. So it often happens that when an unincorporated association gets started, somebody, one of the founders, will hold the cash, will hold the money that is fundraised. It'll be put in a bank account, or it'll be put in a jar or something, under their desk. It's important to understand that although that individual physically holds the property, it doesn't mean that property is theirs. They're holding that property on behalf of the group as a whole. And that property belongs to the group as a whole, which is why by default, the law assumes that what you're going to do with the property will be decided by consensus. If you don't want it to be decided by consensus, so for example, you want the executive committee to be able to make decisions quickly, so you don't want them to have to consult the whole membership every time, then this is the kind of thing which would need to be written down, for example, in a constitution. I sometimes get the question, does it show up so an individual is holding the property in their own bank account? Does that mean they have to pay taxes on the property that they're taking in for the unincorporated association? And the answer is no. If it's because it's not their property, it's being held on behalf of the unincorporated association. It's not a business, so it's not business income, right? It's not an adventure in nature of trade. It's nonprofit. It's a nonprofit for a nonprofit organization, which an unincorporated association has to be. And nonprofit organizations under the Income Tax Act are not required to pay income tax. They're also not allowed to, collect deductions on their taxes. So if you're not registering the income, also not entitled to collect deductions. With that being said, depending on the size of your organization and what activities you're getting up to, you may need to collect other forms of tax like GST and HST. But that's a bit beyond the scope of this presentation. It's just something to be mindful of. One important question that often, when people get started, the last thing they're thinking about is what's going to happen when we end, right? If they don't want to end, they don't want to think about it, right? It's like planning for a funeral, so to speak. It's an unpleasant thing to think about, but it's an important thing to think about. What happens when an organization dissolves? What happens to its property? So, for example, it's common for nonprofits to say our property will go to X organization, or it will go to a charity who has similar purposes to our own, or it will be given to the municipality or the government of Ontario or something. Having clarity from the get-go is important, because when things are dissolving, that people are least in the mood to be having these kinds of discussions. People are leaving left, right, and center. It's not easy to have these meetings, and then somebody's left holding the bag, and it can be really unclear for them what to do. I will note that unincorporated associations can say that upon dissolution, the property will be distributed to the members. That is possible. And that is often the source of a lot of debates when an organization holds a lot of assets. And then some people say, oh, this could actually be pretty profitable for me personally if it dissolves and the members get the assets, right? That can be a source of tension. So thinking through those issues from the get-go, who gets the property when the organization, if the organization folds, can be very important. So that brings me to the end of the first section. Are there any questions? Okay, not hearing
Yeah, and
any.
just a reminder to
Uh,
say, oh, I was just gonna say, reminder, they can type them in the chat, or you can use the raise hand feature and let us know.
Okay, I see there's something in the chat. Oh, there you go. It's the
That's
reminder.
me.
Yeah. Okay, so moving on to choosing a structure. Oh, here we go. Just clears a bell. So glad. Choosing a structure. So I'm going to discuss the pros and cons of incorporation. Then when thinking about, incorporating, there are in fact many different things one can incorporate as. You can incorporate as a business or a nonprofit. You can just becoming a nonprofit. You can then take the further step of registering as a charity or not. You can structure your membership in different ways. And finally, I'll discuss the option of shared platform, or also known as being trusteed, which is where you stay unincorporated, but you develop a relationship with an incorporated entity who, for example, does your admin and so on. So pros and cons of incorporation. Broadly speaking, the pros are that the corporation is its own legal entity. So in an unincorporated association, the individual members are liable for everything they do together and what they do individually, of course. When there's a corporation, it becomes its own thing. So actions taken on behalf of the corporation is liable for. Now, individuals can still be liable if they're negligent, for example, and in certain specified cases, they can be liable. So it isn't like a blank check, so to speak, but there is significant protection in terms of liability when there is a corporation. Secondly, there's a permanent legal existence to a corporation. So an unincorporated association exists as long as the members do. If all the members pass away tomorrow, the unincorporated association disappears. It ceases to exist. But with a corporation, if all the members passed away tomorrow, it would continue to exist, and somebody could go before the court and say that this is why new members should be appointed, and the corporation should continue to exist, continue to operate. Corporations can die, dissolve, and be revived. Unincorporated associations, they come and go with their members. If all their members disappear, the association disappears. Corporate law offers a clear legal framework. There are a lot of details in the Ontario Not-for-Profit Corporations Act, for example, or the Canada Not-for-Profit Corporations Act. And in a way, it reflects the collective wisdom of at least corporate lawyers, which may not be saying much, but it's at least the result of many problems that have occurred in the past that have been thought through, and legislation has been produced as a result saying, okay, this is what we think makes sense as a default rule. That doesn't exist so much in unincorporated associations, where I pointed out a few defaults, but beyond those defaults, there's lots and lots of flexibility. So if you don't want to think through all these questions and you just want a framework, and maybe to make a few tweaks to that framework here and there, then corporate law can be very helpful in that respect. eligibility for funding, that's a big one. So one reason a lot of groups become incorporated is because funders of different kind, from government funders to foundations, say we're only going to fund incorporated entities. We're only going to fund corporations. And the reason they do that is because people can get up and leave, corporations can't. There's a clear legal entity that is responsible, as opposed to individuals where it can be less clear who's responsible in an unincorporated association. Cons of incorporating. There's more paperwork, so you have to go through the paperwork of incorporation. Often it's not required in all cases, but unless you absolutely agree with the default rules, which is rare. It's required to pass bylaws. Then there are annual filings. Filings need to be made every time the board changes, and there needs to be a board every time the address changes, etc. There's paperwork to be done. Now, it's not impossible. Lots of organizations do it, but being realistic about your capacity as a group, I've certainly received questions from groups that incorporated, but had relatively low capacity, and came to the realization after a number of years that it really doesn't make sense for us, given how little we do, for such a chunk of what we do to be dedicated to just keeping the corporation going. There's costs associated with it. So there's a fee of about $155 for incorporation in Ontario. And then if you retain legal counsel, it can cost anywhere between $1,200 to $2,500 for lawyers that know this area. Those are the kind of typical numbers I've seen. And I would note that if you want to become a registered charity, the costs from specialist lawyers, and with charity law, it's quite idiosyncratic. So that is an area where it helps to have a lawyer that really knows that area and practices in that area. Quotes I've seen range from $5,000 to $12,000. So it can be quite significant, especially for a small grassroots organization. Whereas, as I mentioned before, unincorporated associations have no inherent costs associated with them. And finally, it's a more rigid framework to incorporate. You may not want a board. You may want consensus decision-making. There may be rules in the corporate law, for example, keep having addresses listed publicly, having to keep a members register that includes the addresses of each of your members. Some people are very sensitive about their privacy and don't want to be subject to those rules. And in which case, the flexibility of an unincorporated association and the privacy of an unincorporated association may be more appropriate for them. Okay, so let's say you've decided to incorporate and you want to know, well, should we incorporate it as a business or a nonprofit? So it may seem obvious to you, so I'll explain why it's not always obvious. So sometimes organizations want to run as a social enterprise. So their ultimate goal is a nonprofit one. They want to benefit the community in some way, but they see running a business as the best way to benefit their community. And they are not aware that nonprofit organizations do not have to pay income tax. I mentioned that earlier. That's one of the big advantages of nonprofit organizations. However, the Income Tax Act is highly restrictive about nonprofits intentionally earning a surplus. So if the goal of the organization is to intentionally earn a surplus, but then to apply that surplus to some social purpose, it may be a poor fit. They may find that the nonprofit corporate structure is difficult for them to allow them to do what it is they want to accomplish. Businesses have a lot of flexibility to do whatever they want, including pursue nonprofit purposes. The difference is, however, businesses have shareholders, nonprofits have members. Shareholders actually own the business. So the property of the business belongs to the corporation, but then the corporation belongs to individuals. Nonprofits are not owned by anybody. They're controlled by members, but the property does not belong to the members. And so for some groups where they don't want anybody to own what they have, it may be more in line with their mission and their values to be nonprofit rather than for-profit. The legal responsibilities of directors are different in businesses rather than for-profits. So in businesses, the directors, the simplest way to articulate their duty is to maximize profit. That's their goal, to make a profit. It's a business. Now, there's some case law that says that they can consider the welfare of the environment and their employees and other things. But in practice, it's often the shareholders who have the biggest voice in terms of suing a business, and the shareholders' interest is in receiving a return. In a nonprofit, the director's duty is to the nonprofit, and the nonprofit is embodied by its mission. That means that nobody can sue the business, nobody can sue the corporation for not making enough of a profit, right? It's a way of accountability, the board being accountable, that tracks closer the values of a lot of nonprofits. So that's something to consider if you think you'll ever be in a situation where somebody may sue the board. Thirdly, businesses and nonprofits are not eligible for the same kind of funding. There are sources of funding which businesses can access, which nonprofits can't, and there are sources of funding which nonprofits can access, which businesses can't. So organizations will, in general, really want to pay attention to what's our projected revenue model? Where are we expecting to get our funding from? And if that funding source that we plan on getting a significant part of our funding from is geared towards businesses or is geared towards nonprofits, well, that might be a very important factor in deciding whether to incorporate as a business or a nonprofit. Okay, so let's say you've decided you want to incorporate as a nonprofit. There is then the further question of do we want to register as a charity? So the first thing I want to clear up is that nonprofits and charities aren't the same thing. Incorporating as a nonprofit does not give you the ability to issue tax receipts to your donors. It doesn't, as of now, the rules may be changing soon. It doesn't give you the ability to receive grants from charitable foundations, who, as of now, are limited in who they can give grants to other qualified donees, which is a term which mainly means other registered charities. So the question is, if we want to be able to issue tax receipts and we want to be able to receive grants from foundations, what do we have to do? Well, a charity is a nonprofit whose purposes and activities fall exclusively within 4 categories. So they're a more narrow kind of nonprofit. The 4 categories are as follows: relief of poverty, advancement of education, advancement of religion, and other purposes beneficial to the community. Now, that 4th category probably sounds pretty vague. It is. It's a bit of a catch-all for things that courts have found to be charitable over the last 400 years, 418 years of case law. So it includes things like protection of the environment, relief of conditions associated with age, support of youth. There are a number of other purposes that fall under this category, some of which are quite fun, and we could get into if anybody wants to get into charity law trivia. But the point is, you have to fall exclusively within these purposes, and so charities need to be. They have less flexibility than nonprofits. Nonprofits can pretty much do anything other than earn a profit, as long as it's furthering and connected to their purpose. Charities are really restricted in terms of their activities. Their activities have to support their purposes in ways that the law has recognized as being charitable. So, for example, it may be intuitive for all of us here that part of relieving poverty is preventing it in the first place. But charity law says the prevention of poverty is not the relief of poverty. Somebody needs to already be impoverished for them to be eligible for support by a relief of poverty charity. So if you're a poverty organization, but your methodology depends on preventing poverty rather than relieving poverty, you may find charity law very constraining. And so there are other examples of this. If you want to learn more about what the Canada Revenue Agency understands all of these categories to include, then I would suggest you go to the Canada Revenue Agency website, the charities section, and they have a list of guidances that they have on different topics, and just like scroll through the A to Z list, see what are the interesting sounding guidances. They're not particularly user friendly, but there's a lot of great and really valuable detailed information there. Now, one area which is interesting in which registered charities actually have more flexibility than just nonprofits is earning revenue. So I said nonprofits, if they intentionally earn a surplus, run the risk of being taxed like a business. Registered charities, however, can earn revenue through what is called a related business, or by charging for their charitable activities. So, for example, an opera company can be charitable and they can charge admission. The University of Toronto, where you heard, I went to law school. Let me tell you, did they ever charge? So you can charge actually quite a bit. But as long as you're charging for a charitable service, it's fine, and you can even earn a surplus and it won't be taxed. So depending on what your revenue model is, registered charity status might actually be quite interesting and useful to you. I will note that nonprofits, unless you're in a specifically regulated field, like childcare or long-term care or something like that, where there's a dedicated regulator to you, nonprofits as such aren't actually that regulated by anybody, which has its pros and cons. But registered charities are regulated by the Canada Revenue Agency. So one thing to consider if one is thinking about becoming a registered charity is one ready to face potential scrutiny, to face an audit from the CRA? Has one taken the time to build the systems to actually comply with charity law? And thank you for sharing that link. Okay, so now let's talk about membership models. Membership models are a crucial aspect of figuring out what structure one's organization is going to take, whether or not one incorporates. So membership models are relevant to unincorporated associations, and they're also relevant to incorporated nonprofits. So here's the key thing. Basically all nonprofits, there are very, very few exceptions. Basically all nonprofits have members. As I mentioned when we were comparing for-profits and nonprofits, members are the people who control the organization. They have the power to elect the board in an unincorporated association. By default, they decide things by consensus. They're really where the official legal power lies. Boards and executives are typically responsible for oversight. They're responsible for carrying things out and appointing people, but they're subject to the control and the oversight of the members, which means that who the members are matters a great deal. And there's lots of flexibility in terms of how to structure membership. There can be multiple kinds of membership. They can have different rights and so on. So I'm going to go over 6 different kinds of membership, and there's more detail on our website about different membership models. So I'm going to review what each kind means, and there are different names for each of these. What each kind means, and then the pros and cons of each kind. And they're always trade-offs. This is one of the reasons I say, I don't know what's best for your organization. You probably know much better. There's no one best model for everybody. The first and probably simplest kind of membership is what we call open membership. Anybody who supports the organization can be a member. And intuitively, this is how a lot of organizations operate, especially when they first start out. Yeah, you're coming to our events, you're getting our newsletters. Yeah, you're a member. The pro of this is that it's open, right? It's low barrier to entry, so it's easier to have a wider base of membership, which encourages participation. It encourages a feeling of community, etc. The downside is it can be more difficult to keep track of who a member is, and remember that's really important for figuring out, what are their rights, who do we have to keep in mind, whose approval do we need, etc. Another downside is that people who don't share your vision or values can come into the organization quite easily because there's such a low barrier to entry. And they could shift the direction of your organization. In extreme cases, they can take over the organization. So it's open, so that's inclusive, but that can also lead to administrative difficulties and exposure to alternative viewpoints. The next step from open membership is what we call semi-open membership. This is where you say anybody can join as long as they meet XYZ criteria. So that criteria could be as long as they pay a certain annual fee. It could be as long as they sign a code of conduct. So Pillar kind of did this at the beginning of this meeting by setting out the ground rules for, if you're going to be part of this group that we formed at this session, you have to follow X, Y, Z rule, and we reserve the right to kick you out if you don't follow these rules. That's a simple form of a semi-open membership that an organization can have. And you can be very creative in how you set the criteria for membership. Thirdly, there's what's called a self-perpetuating board. And the question I get asked very often is, in this organization I'm involved in, the directors are the only members and they elect themselves. Is that allowed? And the answer is, for better or worse, yes, it's allowed. It's a perfectly legal structure. It's not always a good idea. And the advantage of it is that it keeps the people in charge focused. It's a small group of people. So if they have a common vision, that's easier to manage. So you're less exposed to other people coming in and maybe changing the direction of the organization. It's administratively pretty easy to manage because it's a small group of people. The con is that that group of people is not necessarily accountable to anybody outside of them. They can have meetings where they pass very important decisions about the bylaws and nobody else has a say. Just because somebody is a supporter of the organization doesn't mean they have a right to attend those meetings, for example, right? Membership is a specific legal term that would be defined in the governing documents, especially if an organization is incorporated. And just because somebody feels like a member, just because somebody is referred to as a member in, for example, flyers, doesn't mean that they're a member for legal purposes. And so you can have organizations with very closed structures where many people think or believe that they're members, where it turns out they're not actually members. That can have a demoralizing effect on the community. So to summarize, with self-perpetuating boards, the pro is that you can stay focused with the vision and it's administratively pretty easy to run. The con is that there isn't the accountability. It can be confusing and demoralizing for the broader community. A fourth way of structuring the membership is where there's only one member. So if somebody wants to start a nonprofit corporation, one person is enough to do that. And then that one person holds all the power as far as naming the board and appointing the auditor, receiving financial statements, etc. So you could see how this would be, all the pros and cons of a self-perpetuating board is just made even more so with a single membership model. So it's fast to set up. You have a singularity of vision. It's administratively about as easy as it can be. But the con is there's even less accountability. You're not necessarily building this wide pool of thought. You're not benefiting from different perspectives, diversity of perspectives necessarily. Of course, you can benefit from perspectives without them necessarily being a member. But the point is where one person actually holds power in the organization, all the advisory committees in the world can't necessarily compensate for one person who won't listen to those advisory committees. Next, we come to and I should note there's also a public relations to think of when you think of the different membership models. So, last year, or well, actually, it's a little while ago now, we had, for example, the WE scandal, where a lot of the media was concentrating on the governance structure. And all kinds of people were interpreting all kinds of things based on the governance structure. So one thing to think about is, well, what message does our governance structure send to the public? Is it consistent with what we claim our values and our mission to be or not? And that doesn't necessarily tell you one or the other, but it's something to be mindful of as one thinks through the membership model. Hybrid members. So a hybrid membership is where you have multiple classes of members, multiple types of members. Some of those members are voting members, others are non-voting members. So for example, you could have a little league where the parents are voting members in the little league, and the players, the children, are non-voting members. So they're important stakeholders in that community. So, they have rights to attend, let's say the annual meeting. They have the right to maybe form a youth advisory committee to talk to the league about the concerns they're experiencing and so on, and what they want and need. But they do not have control over the property or the assets. They're not holding a veto over important governance decisions that they may not be in a position to fully appreciate. Hybrid memberships can get very intricate to reflect different regional interests, to reflect the interest of different types of stakeholders, to reflect different language communities even, and so on. The pro of a hybrid membership is that it's a way of building in diversity. It can be consistent with the values and vision of the organization. It's a way of including, having a broader base of people involved in the governance of the organization without necessarily having to give up control of the organization. Some of the cons are it's more complicated to run. So there are administrative difficulties. It takes time and attention to keep up the hybrid membership, to make sure you're keeping track of who's what kind of member, what kind of rights. It takes more thought to figure out what the rights are. And there can be potential for confusion as well. And finally, representative members. So I've seen different versions of this. It's basically where you have the members are people who are elected by some group which are not themselves non-members. So I've seen it in residents associations where the member will be a building. I'm not even sure if that's legally valid, but supposing it is legally valid, the way that works in practice is the building as a whole sends one person to the meeting who they themselves are elected somehow within the building. That person then becomes the member on behalf of the building of the organization. Similarly, churches, religious institutions often have a regional kind of representative membership model. So different parishes, for example, or different churches will elect a representative, and that representative will then go to some regional caucus or something like that. So there are different versions of this, but the idea is that there's some group, and you don't want to have to go to the trouble of every individual being a member, but you want them as a collective to be represented as a member. So you have them elect somebody, that person then acts as the member. The last thing I'm going to talk about in this section are shared platforms. So this is also referred to as a trustee relationship. So this is where you join an organization and legally become an activity of that organization. So that organization, maybe they're incorporated, maybe they're a registered charity. So they have the ability to issue tax receipts. They have the ability to receive funds from foundations. You didn't have to go to the trouble of incorporating. You didn't have to go to the trouble of registering as a charity. You didn't have to wait. You didn't have to pay, right? You joined an organization that already went through all those steps and already has some expertise and some administrative capacity to manage everything that goes along with that status. But you're part of them, and they officially receive all the documents and the money and so on, and then but your people actually carry out the activity. So if you're in this kind of relationship, you have to follow their management processes, because ultimately it's them that legally exists. You're a part of them. You don't exist as a separate entity. You may have some reporting requirements, and many shared platforms certainly require their trustee projects to regularly report, and it's a very important relationship to keep up. And the way you communicate to the public will often change somewhat as a result of you being taken on by this shared platform. So, for example, the CRA expects from shared platforms that their projects don't have separate branding. That on all of the project branding, it says, we are XYZ project, a project of the shared platform. And so the shared platform's name is always there. So it's always clear that legally speaking, that's who's acting. So depending on how much flexibility or autonomy you need or want, and whether there's a shared platform in your community who is appropriate for you to work with and who reflects the interests and needs of your community, this can be a better or worse model. There's often a fee associated with it. So the shared platform will take, I've seen anything from 2 to 20% of the funds that you're receiving. So that's also something to keep in mind. As an option, that's sort of in between staying as an unincorporated association and incorporating. I will note that the Ontario Nonprofit Network is going to come out with some resources pretty soon, I think in the next month, that will share some best practices for shared platforms. So that brings us to the end of this section. Are there any questions? So some interesting questions.
Can I ask quick, Benjamin? I know you're talking about shared platforms. Does that also include, I don't think it happens very often, but there are instances where an organization will flow money through to someone who's not incorporated, a group that's not incorporated. It's not very common, but is that also an example? I know there's specific shared platforms. I think like Tides is one, and there might be a few others, but if an organization does it, it's as well, would that fall under the same?
Yeah, it's the same general idea.
Yeah.
I will say the word flow through is a bit of a red flag word, especially for the CRA. So in general, it's something to be cautious about using that term, especially when it's a registered charity, because registered charities cannot just flow through funds to unincorporated associations unless those associations are somehow a charitable beneficiary. So they're actually delivering a charitable activity by giving them the funds, for example, relief of poverty. But yeah, a nonprofit can certainly give, for example, grassroots grants, so some small amount of money to an unincorporated group. That's certainly something that could happen. And that's starting to look like a potentially shared platform relationship. And it's a spectrum, right? Some just administer the funding, others provide a network and community and training and so on. So there's very much a spectrum of what counts as a shared platform.
Okay, I know it's not a super common thing that happens. Anyways, and obviously it has to, like you said, there's CRA and it has to be well connected to mission, and that's why it's just not, it doesn't happen very common.
Yeah. So I see the question from Paul: is a student council an example of, or at least a reasonable analogy? So by student council, do you mean are they an example of a shared platform, Paul?
No, that goes back a slide. That was, are they an example of what were we talking about?
Oh.
or representative members. We're talking about representative members where there's this association called the Student Council, and it's made up of people elected by classrooms who aren't themselves members of Student Council. I was just curious if that was a useful analogy
absolutely.
to sort of imagine what that looks like.
Yeah, absolutely. Student council. And by the way, and this in fact is how I got interested in nonprofit law in the first place. A lot of interesting nonprofit law models happen on campus without people realizing it. Student councils on universities and college campuses are also a fascinating example of a shared platform, because often they are providing grants and they are providing supportive administrative structures for clubs, which are themselves unincorporated associations in a lot of cases. So it's a really rich area to look for different examples of different models. So I appreciate you bringing that up. And yes, it would be a representative, an example of representative model.
And I just found ONN. I don't know if that's the what you were talking about, if that's new on their website. I found a resource page around shared platforms. It could be.
Yeah, so that's been there for a while. So that's going to be updated in a month. There's going to be a webinar, which people are welcome to sign up for. So you can check out ONN's, I don't know if they have a calendar or something on the website. I should know that, I work there, but check it out. And that'll be released, I think, sometime in the next month. There'll be more, but there's already some good resources on that webpage. Please correct me if this is a mispronunciation, but Viviana, could you specify more what you want to hear about with shared platforms?
Oh, hi, I just added a question. So it's basically about, so what happens is, because we're talking about grants, right? But what happens if, for example, an incorporated group that is part of that shared platform, right? And is receiving a donation. So this donation, because it's a charitable, it's coming through the shared platform, right? That donation is taxable. However, the group is unincorporated. So I'm just curious about how that flow will go with donations.
So where the charity, the shared platform issues a tax receipt, that donation has to be to them. It's their money, it's their property. Okay. Now, it may be that the donor said something like, this donation is for the sake of this project, right? In which case, the charity can apply it to that project, but it has to be their project. They can't give it to somebody else. So the way shared platforms work is the charity makes the unincorporated association part of itself. So it ceases to be a separate unincorporated association, and it becomes a project of the shared platform. So there's only one legal entity, which is the registered charity, is the shared platform. So in practice, the way this works is the charity signs all the contracts. The charity's branding is on everything. The charity's management structures and policies are applied to the project. All the people who are working on the project are volunteers and employees of the charity, and they may have agreements with the charity showing that they're employees and volunteers. It's the charity that really has the property and the program and the entities.
Okay, thank you so much.
My pleasure. Next question: can nonprofits only receive funds from other nonprofits and companies, not from registered charities? So nonprofits that are not registered charities can receive funds, and I'll just say grants and donations from individuals, nonprofits, businesses, government. They can charge for services to anybody. So charities are welcome to purchase services from nonprofits. But when it comes to grants, that's correct. Registered charities cannot currently just grant to nonprofits. They can only grant to what are called other qualified donees, a term which mainly includes registered charities, and it includes some other entities like registered Canadian amateur athletic associations and so on, which doesn't affect most people. So yeah, registered charities cannot just grant.
Yeah, so a registered charity can grant or give funding to another registered charity, not
Yes.
to nonprofit that are not registered.
Correct.
Okay, got it. Thank you.
Is this, thanks, okay. Okay, so yes, thank you, Asha, for bringing that up. Bill S-216, Canadian charities may soon say goodbye to the inflexible own activities requirements. So there is an act currently, it's going to receive second reading, I think, May 13th. And it would change the rules and would allow charities to carry out their activities by granting to non-charitable entities, as long as they can be reasonably sure that the grants they make are used exclusively for charitable purposes. So it hasn't yet passed. So it may change the rules, so stay tuned. But as of today, the rules I just described, registered charities cannot just grant to nonprofits. That's the rules as of today. And as far as crystal balling goes, I cannot speculate on the relative positions of the different political parties and whether or not it will pass.
I could just throw in that in terms of the crystal balling, maybe that even were it to pass, built into it is a 2-year review period. So changes wouldn't be changes to the actual funding ecosystem wouldn't be immediate, not even imminent. And during that 2-year review, the reasonable person test could be fleshed out in ways that make it closer to direction and control than some people are lobbying for right now. So it isn't really clear where it might end up, but that is the intention of the bill, right? Is to make it easier for charities to work with non-qualified donees without requiring huge compromises from the non-qualified donee.
Yeah. So thank you very much. That is very helpful context. So moving on in the interest of time. So how to incorporate, I'll talk a bit about your nonprofit's name, who is involved in the initial corporation at a minimum, your nonprofit's address, your nonprofit's purposes, and the first meeting after you get incorporated. Because people often think, unfortunately, that once you filed your papers, you're done. But in fact, there's a first meeting that needs to happen that's necessary to make everything legit, as the kids say. So your nonprofit's name. Nonprofits have a corporate name. That's their official legal name. It goes on their documents, their governing documents, their contracts, etc. They can also have trade names. So that's the name they go by in the community. They may go by a number of different names. It's important to note that trade names have to be registered under the Business Names Act. Even though nonprofits aren't businesses, they're covered by the Business Names Act. In Ontario, they have to register the fact that they have trade names. I've seen nonprofits get into a lot of trouble just because they used a slightly different name from their official name and didn't register the trade name. This is something in general that nonprofits will want to pay attention to. What happens when you first incorporate is that the government asks you for what's called a nuance report. It's basically a search that tells you that there are no other Ontario or federal corporations that have the same or a similar enough name that it would be deceptive to the public, that people would be confused, which corporation are you? Note that this nuance report is not the same as getting trademark protection. So that's something you need to file with the Canadian Intellectual Property Office. It's not an area I know very much about. It's just something you should know, that just getting incorporated does not protect your name and it doesn't protect your brand. So your nonprofits, incorporators, and directors. So you must have at least one incorporator. So remember when I said you can have a one-member model, this is what I meant. You only need one person who has the powers of member when you first get incorporated. They have the initial power to elect directors and pass bylaws at the first meeting, which we'll talk about soon. You must have at least 3 directors. What are the qualifications for these directors? They need to be at least 18 years old. They can't be bankrupt or legally incompetent. They can be incompetent generally, but they just can't be incompetent for legal purposes. Now, probably you don't want your first board to be incompetent incompetent individuals. I'm sure they have many other strengths, but the point here is that incompetent is something found by a court that they can't handle properly. I apologize for that slight humor. Here's something interesting. They do not have to be Canadian residents. And this is a question I've gotten a number of times, especially if you work abroad. They can be coming from other countries. The official address, as I'll mention, needs to be in Ontario, but the individuals on the board do not need to be in Ontario. And your initial directors have to consent in writing to act as directors, and there's a form available online through the Ontario Forms repository that they can sign showing that they consent to be directors. So your nonprofit's address. You have to provide an address in Ontario. The address will be publicly searchable through the Ontario Business Registry. So keep that in mind, especially when organizations first start out. It may be a personal address of the people involved, so they may not want that to be publicly searchable. The default, and what is this address for? Unless your articles, bylaws, or board resolutions say otherwise, this is the address where your important records will need to be accessible. So you have to keep your important records at this address, or at least if you're keeping your records online, there needs to be some computer at this address that you can access those records from. Board and members meetings will take place at this address. Again, it's just a default. You can pass resolutions to say, yeah, we'll have the meeting somewhere else this time, but by default, it's going to be this official address. And thirdly, the government and others are going to send important documents to this address. So when choosing an address, keep in mind that this is the purpose it's going to have to serve. And for organizations that do not have access to a physical address, you don't have a headquarters, a few strategies to think about are using the address of an accountant or lawyer or consultant you're working with, using the address of a municipal community center. Sometimes they offer this service. Using the address of a shared platform. Sometimes shared platforms offer that service to other incorporated entities, and so on. Your nonprofit's purposes. As I mentioned, purposes are really important, especially for charities, because everything you do has to fit within your purposes. So a nonprofit can have any legal purpose other than making a profit. And there are some weird ones out there. You know, I once spent a summer just looking through the list of all nonprofit corporations in Ontario. It's a fun activity for someone with a lot of time. You can have commercial purposes, but you must say that any surplus will not be returned to members, but will be reinvested in your purposes. So keep in mind that your corporate law rules, which say that you can run a business, you can have a surplus, are different from the tax law rules that say how that surplus is going to be treated for tax purposes. Nonprofits can carry out businesses for corporate law purposes. They just may be taxed as a result of that. If you're willing to be taxed, then it's power to you. The corporate law allows you to do it. Charitable purposes are a subset of nonprofit purposes, and we've already talked about what falls in charitable purposes. So once you've been incorporated, so you file all your forms with the Government of Ontario, and you can go to the Ontario Business Registry website, look up how to do it. There are 3 basic ways to file your forms. You can do it online through the Ontario Business Registry. You can do it through a third-party provider, and the third-party providers are listed on the Ontario Business Registry website, or you can mail in the forms. And you can download the forms from the Ontario Forms repository, download the PDF, fill it in, and mail it in to the government, and the address is specified on the form. So those are the 3 ways you can do that. So after, and the most official step, the really important form that you need to send in is called your Articles of Incorporation. So once you send in Articles of Incorporation and the government sends you back, stamped and approved, yes, you are incorporated, your directors must meet to do some or all of the following things at their first directors meeting. Approve a set of bylaws. And again, bylaws is another name for constitution. It just means they have to approve a set of governing rules. Call a members meeting. So everything the board does, like I said, ultimately subject to the members. So the board meets, but then the members or member needs to meet to approve what the board did. Make banking and financial arrangements, such as opening a bank account. appoint officers. So directors are one thing. So you say when you first file for incorporation who your first directors are going to be, but then there are officers. That's like president, secretary, etc. Those are individuals who are given a specific task. Those people are only named once you're incorporated at the first directors meeting. The Ontario Not-for-Profit Corporations Act the only requirement they have for officers is that you have a chair. The other officer positions are entirely up to you. So once the board has met to do all of that, then a members meeting needs to be called to do any or all of the following: vote on the proposed bylaws that the directors approved, elect a new board. So that first board is only valid until the first members meeting. After that point, they cease to be effective, and the member or members have to elect a new board. It could be the same people, but there needs to be a vote that goes on. And appoint an auditor or person to do financial review. And you can go on our website and it will explain what financial thresholds are you required to get different kinds of financial review. If you do not do this, if you do not pass bylaws within 60 days of incorporating, the default bylaws will automatically apply to you. You can Google Ontario Nonprofit default bylaws and you'll see what those rules are. Those may not be appropriate rules for you. They may be, in which case, power to you and you don't have to do anything. But if they aren't, you don't want to be stuck with them. This is my email address. Feel free to reach out to me with questions. This is the URL for the nonprofit law. We still have a few minutes for questions, and I'm happy to stay on for 10 or so minutes to answer more.
Yeah, so I'll just take this quick opportunity to see. I think, Paul, you had a question that you typed in the chat that was from a DM.
Yeah, I had a question come to me by way of I was chatting with somebody through DM and their settings were still there. So this is where the question ended up. Is it possible for boards of unincorporated associations to obtain directors and officers insurance?
Fascinating question. Not sure. I will follow up because I'd love to know that. This is why I love questions. I always learn more than everybody here. The next question is
That might be it. It's me posting all kinds of evaluations and events and things.
Okay.
I think that might be the only question in the chat. I'm not sure if anyone else had a question they wanted to ask live. As Benjamin mentioned, we still have a few more minutes, and he can stick around for a little bit.
Tremendously clear as always, Benjamin. Thank you.
Oh, my pleasure.
Yeah, that's what I loved about these last two presentations. Lots of good information and really kind of straightforward, good resources. So does anyone this is your chance, we have a few more minutes. If you have a question or wondering about something, this would be the opportunity. And of course, Benjamin's given you his contact information, so you could follow up with him. And I would really suggest checking out that website. There's excellent information, excellent resources for everyone. Cecilia, got a question?
Susanna, can I ask last if there's a few minutes left?
Yeah, for sure.
So if you're a nonprofit and you're not registered, and there's a company or an individual who wants to give you a donation, but you can't issue a tax receipt, right? Because you're not registered. What's the other option to give, a perk or, to that donation or sponsorship in this case, maybe? How do we, how can you solve that or keep that sponsor or donor, although you can't issue that tax receipt?
Yeah, and this is one of those areas where I don't necessarily have any special insight as a lawyer. Unincorporated associations can figure out all kinds of benefits, recognition. Every surface is a potential sponsor recognition opportunity. Different kinds of crowdfunding campaigns are great places to look for examples of like tiered offerings. I was once part of a play, a production that was an unincorporated association, and we produced like thank you videos from the cast members, and we called out various supporters during performances and stuff. So that's something that I would ask, on Facebook, a lot of great nonprofit Facebook groups. Other people here probably have good ideas about how to recognize, which I would encourage you to put in the chat if people here have ideas about how to recognize them. But legally speaking, there aren't really many restrictions other than you can't give a tax receipt.
Okay, thank you, Benjamin. And thank you,
Asha.
Paul. I see Paul's answer in the chat. Thank you.
Yeah, so yeah, that should be the case. If it's a business, they should be able to improve their tax position by making that a marketing expense, right? So that would be instead of a tax receipt, they get a tax offset.
Yeah, as long as you recognize them like on website,
Yeah,
social media.
if they can make a reasonable case that it's a
Yeah.
marketing initiative for them, then that's where they're rewarded back by the system.
Awesome.
Yeah,
Okay,
actually,
great.
that's a good point, and I can actually provide some legal information, which is the thing to be mindful of in order for something to be recognized as a marketing tax deduction, is that it has to be reasonable, that it's actually a prospect. So being able to explain why, like, this is your target market, or it makes sense, there's like a brand alignment or something, all of that helps them, if they're ever audited, make the case that this was genuine marketing and this wasn't them just trying to write off the donation that they were making.
Okay, awesome. Thank you.
Asha, thank you so much, Paul.
Thank you. I have a question. So I'm currently a freelancer morphing my activities into social enterprise. And I'm just wondering, where would I fall into any of those laws, just being in the first phase of setting up a business?
So this is a great example, and I can't advise on your specific case, but this is a great example. I'll go back in the slides to asking the question, business versus nonprofit. So an unincorporated, so if there's only one individual involved, first of all, we didn't talk about that. An unincorporated association is 2 or more people. If there's one individual involved, and they're doing it for nonprofit purposes, I don't know that it has any formal status necessarily. If they're doing it for for-profit purposes, so making a living, that kind of thing, then that's in the sole proprietorship category. Now, when you get to the question of, well, I'm formalizing, there may be liability in my work, etc. Do I want to incorporate it? Is it worth it? It is possible. Like, people can earn a living working for a nonprofit. The question is, are they drawing an income as a result of their work, meaning they're being paid a salary or a wage, or are they being paid basically whatever income the organization gets, which looks much more like the relationship of a shareholder to a for-profit corporation. It looks like that organization is operating on a for-profit basis. So it depends how one wants to structure one's income. If one is satisfied with structuring it as salary, that's fine. But if one wants the flexibility of drawing in whatever income comes into the entity, then nonprofits are not well suited for that, and they may end up being treated as a business by the CRA anyway. So the tax advantage is lost. So that's something to think about. How do you expect to draw income?
Thank you. Yes, this is purely one-person operation and is for love right now, drawing no income with hopes to generate income to reinvest into community programming. So thank you very much.
There's one more question there in the chat as well.
Okay, great.
Did you see it there? Do you want me to read it out to you?
Yes, I've missed it. Is there any case where a group that is incorporated and part of a shared platform will need to file tax? That is incorporated. So, okay, so this is interesting. I'm increasingly learning about shared platforms relationships where the group is actually has a separate legal existence and receives administrative services from the shared platform. Where the group is separately incorporated, the question of whether or not it needs to file tax is the same as it is for any taxpayer. So if you go online to the CRA, it explains when nonprofits need to make a nonprofit annual information return, which is based on your revenue, the amount of your revenue, and also certain types of investment revenues if you have investments. Whether you need to file, GST or HST depends on, what are your supplies and how are you making them available to the public, etc. And there are lots of exceptions for nonprofits who don't. Also, the amount matters, and also filing a T2 at different levels. This is not something I have a huge amount of experience in. It might be something to speak with an accountant who's experienced in working with nonprofits but the answer is yes, even though you work with a shared platform, you may sometimes need to file various tax forms.
Does that hopefully, Bibiana, does that answer? Oh, there's a thank you. Perfect. Awesome. Okay, so Paul, you're gonna take our last question.
Sure, thank you. I'm not even sure that I can formulate this question well, and Miriam might actually be able to ask it better than I can. But I was wondering, Benjamin, if you could elaborate on, you sort of talked about a kind of cumbersomeness of surplus profit going to social purpose. I mean, the effect that I got of it was that it was sort of easier for a social enterprise to incorporate as a business and direct profits to social purposes than it was for a social enterprise to incorporate as a nonprofit and risk having a difficult time showing the way in which surplus profits are directed back to social purposes. Could you clarify that for me a little bit? I know that, and I say that Miriam might be able to ask this question better, because I know that in our coaching of social enterprises, a lot of folks join with the idea that they will be nonprofit social enterprises, but exit with an idea that they're really going to be businesses with social purpose.
Mm-hmm.
Yeah, I mean, I think you asked the question fairly well, Paul. I think a lot of the time when folks come in with the intention of not-for-profit, it's also because it's more around the idea of they want to do social good, but they don't necessarily know those complexities of the not-for-profit structure, which you spoke to. So then they're not really sure, and then they end up going the for-profit social enterprise route because they want the control of being able to operate without the board governance and all of that. But yeah, that's a really great question in terms of the ability to demonstrate the profit distribution and the clarity around that. So yeah, I think you asked the question.
Right. So this is very interesting to hear about. This another example of how I learn more than anybody else in these sessions. So there seem to be two parts. So one is the question of the cumbersomeness of how that income is going to be treated. And secondly, this question of control. So the question of how the income is going to be treated is really a question of tax, meaning nonprofit corporations can do it. They have flexibility to operate as a social enterprise, have commercial purposes, run businesses that can even be like enormously complex and extensive businesses. The question comes, how's the CRA going to look at it, right? And the CRA has taken some unfortunately inflexible and rather, whatever, I've not to editorialize, but they've taken some inflexible positions that mean that, in effect, intentionally earning a surplus, so planning to earn a surplus, not even across the organization, but planning to earn a surplus from an activity, can draw the interpretation from the CRA that there's a business being run, and that income, that surplus, will be taxed as if it were being run by a for-profit, even if that surplus is then reinvested in social enterprise. Now, that's not a prohibition. That doesn't mean it can't be done. It just means it's going to be taxed. So that's something to be considered in terms of thinking about the margins and the business model and the economic feasibility and so on, which is not for me. That's for a consultant or an accountant or somebody more numbers minded to talk about. To my knowledge, it is relatively rare that nonprofits ever go to the CRA and say, yeah, we're willing to be taxed. So what often happens is nonprofits do this to a greater or lesser extent, keep their heads down and hope they never get noticed. And in fact, the CRA did a study back in 2014 on the degree of compliance by nonprofits with the Income Tax Act rules for nonprofits, and they found, I think, something like a 50% non-compliance rate, an enormous non-compliance rate. And it's because the rules in no way match the realities of the sector. So, you know, all these kinds of risk calculations about the chance of the CRA noting the kind of, well, do we want to, how do we want to run it? How by to the nose, straight edge do we want to run it? You know, have we taken into account the likelihood into our business model, et cetera, are all questions to ask. But by no means do I want to give the impression that people can't do it as nonprofits. It's not legally prohibited in any way for nonprofits to run social enterprises.
That's helpful. Thank you.
All right, well, those were some great questions and some great discussions. So I'll end things off because we are after time and I want to be respectful of everyone's time, respectful of Benjamin's time, but really big thanks to you, Benjamin, and to Cleo and all of the great information that you always share with us. So thank you. Super appreciative to have you here today. And thanks everyone for joining us. Enjoy your afternoon. Stay well, stay connected, and I'll be in touch with a follow-up email with some links and evaluation and coming up. And with that, so thank you. Thanks for coming. Thanks for being here. Some of you I'll see around. Others hopefully see you in community soon. Thanks again, Benjamin.